Welcome to Fortifying Futures, the podcast that unlocks the secrets of securing your legacy. Each episode is meticulously crafted to demystify the complex realm of estate planning, asset protection, and how your investments are protected. With the expertise of industry veterans and the personal stories of those who have navigated these waters successfully, Fortifying Futures offers more than just information. It provides a blueprint for action. Tune in to Fortifying Futures and transform your legal and financial journey into a strategic masterpiece. Okay, everybody, welcome back to Fortifying Futures. In this podcast, again, we want to help demystify estate planning and all of the nuances that go with it. So we bring in people, real life scenarios that have real questions that can help us and help our listeners better understand what's going on and ultimately not to be afraid of this thing called estate planning. So with me today, I have Nick, and Nick's got a real life scenario and a really great question. We talked about it earlier, and I thought, man, Nick, that would be great. So Nick, tell us what's going on.
Yeah, Brian. So my dad has been wanting to set up a trust with me as the trustee, and I just want to kind of get some of the ins and outs of how a trustee actually functions as the administrator of that trust.
Oh, perfect. Great question. And Nick, you'd be surprised. I get that question a lot, which is really why I wanted to talk about that. And so as your dad, who lives here in Oklahoma, right? I think he lives in Oklahoma. During his lifetime, when he funds the trust, he is called the grantor of the trust, and he gets things started. And during his lifetime, trust administration, or being his trustee of his own trust, is really uneventful for him, right? Not much is going on, taxes are still normal, and it's really uneventful. However, and it will happen when that sad day comes, when your dad is no longer with us, and if you agree to serve as trustee or successor trustee to his trust, you have a pretty important job. And so first and foremost, when you step into that job as successor trustee, you put on the role of a fiduciary. So what's a fiduciary? We hear that term thrown around a lot, and probably people really don't know what it means. It is the very, very high standard that you would owe to all the beneficiaries of the trust. So a trustee owes a fiduciary duty to all the beneficiaries. And that fiduciary duty is the so high a standard that the trustee must act in the beneficiary's best interest.
Okay.
So there it is again. The trustee must act in the beneficiary's best interest at all times. Even if it's hard or bad for the trustee still has to take those steps for the benefit of the beneficiary. So a fiduciary duty is a very incredibly high standard that the law puts on trustees. So when you step into that role, when you say, yep, I'll do it, I'll be trustee, know that you're going to be a fiduciary. And so to that end, then it really matters, Nick, the next question is, what are some of the assets that you think your father might have in his estate?
So my dad owns his house. He owns a couple of vehicles. He has some mineral rights in South Oklahoma. And I believe he has at least one investment account.
Right. Right. Well, those are all great things to have, and all of those assets kind of make up the estate of your father's estate. And so when you step in, it will be your job to steward those assets or shepherd them to the beneficiaries pursuant to whatever rules your dad has put in place. And so what would really is going to happen in those particular instances, when you become trustee, you will be the legal owner of those assets. So you will have to handle the house, right? You've got to pay bills on the house. You'll have to pay taxes. You'll have to ensure there's insurance on the house, right? You probably call the existing insurance agent and make sure that's going on. That's pretty standard. You are going to be in charge of the mineral rights, so you have to make sure those minerals are still being paid. You have to make sure the division orders are signed, if there's any of those. For the investment account, you have to make sure the investments are working and they're following their investment objectives or whatever you've set out. And then for the vehicles, you got to make sure there's insurance on them, and then you've got to get them titled into the name of the trust if they're not already there. And then once you've secured all those assets and have control of them and a good understanding, then you have to do what the trust says. So I don't know what your dad's trust says, but it could say one simple thing, hey, as soon as I pass away, take all these assets and divide them among my heirs. And here are my heirs, A, B, and C, or whatever. Or it could say, hey, take all these assets and the trustee holds them
Hmm.
for the benefit of these heirs, right? And so, depending on what that trust says, then you'll be responsible for following those orders. If it says, hey, take my assets, divide them up 3 ways, and sell everything, that's pretty easy,
Yeah.
right? You have an estate sale, you sell the couches, you sell the clothes, you sell whatever's inside the house, then you sell the house, right? And then you sell the cars, and then you get all the financial information and divide that account up 3 way, and then you're cutting checks,
Yeah,
and then you're done.
not a hard job, relatively speaking.
Not a hard job. I will tell you, the hard part comes into the stuff that's in the house, right?
Hmm.
I'm sure your dad's estate is important to him and is important to the heirs, but what people argue over the most is the stuff inside the house, right? Maybe it's a rug or a couch or a picture frame or some kind of memento for the family. And I mean, I would really encourage your dad to take the time when he does his estate plan to be very specific on who gets what, because people tend to argue over those things.
And make note of everything.
And that's right.
Yeah,
That's
yeah.
right. That's
Very
right.
detailed.
That's right. As detailed as he wants to be to ensure that those things are passed on. And so it's really easy to divide the proceeds of a house, right? We get the check in, we go to the closing company, the check comes through, and then all of a sudden we split that up 3 ways. Financial securities, same way. Now, I think, I'm not sure if you mentioned it, but does your dad have an IRA or some kind of investment account?
Yeah.
Okay. So IRAs are just a little bit different. For the most part, he probably doesn't want to name his trust as the beneficiary of his IRA. But again, I don't know his circumstances, so that would be up to him. But there are tax benefits to naming individuals as the beneficiaries of the IRA. And not all circumstances, but generally that's probably a good default option, is to name inside his IRA whomever he wants to inherit that money. I mean, if he wanted to name his new favorite attorney,
Right, of
me,
course.
to inherit his IRA, then he could write that inside his beneficiary designation form, and that happens outside of his trust.
Mhm.
That would be a separate agreement, kind of like life insurance or anything like that.
Okay.
His
Yeah.
beneficiary designation and his IRA is outside of the trust. Now, in my personal situation, I have special needs in my family, so we wouldn't want to give a special need person their own IRA in general because it might impact some government benefits. So there are a lot of nuances to think about when it comes to that. But I think for the most part, it's probably a safe default to assume that. So we can divide the IRA pretty easily on the beneficiary designation forms. Life insurance, same way. And then when it comes down to dividing up the couches and stuff, that's harder. Probably have to sell it and divide it. Vehicles, the same way. How are we going to divide those things?
Right.
It's hard to cut a car into 3 ways.
Yeah, you got to get the tools out, I guess.
That's right. Just get the blowtorch, cut it in 3 ways. So if your dad wanted to, he could give a specific bequest in his trust of something that was important to him. Maybe it was he wanted to make sure a car went to this person, or a couch went to this person, or maybe his favorite watch went to that person. So in his estate plan, he could do that. And you, as the trustee, you would have the fiduciary duty to make sure that those wishes are followed. And as a trust should have a fairly basic flow of how to divide those assets up and what specific distributions come off the top. And then it says probably something like take the rest and residue and divide it up this many ways, right? And so that's fairly basic, but I will tell you.
Just by value, I assume.
Sometimes.
At that point.
Yeah, just by value, if that's what they wanted to do. But just the fact that you asked that question right there shows that it could be a very slippery slope. And if a trustee is administering the trust, they have to put their own personal biases and wants aside, right? So if you're the trustee of your dad's trust, you have to put what you want aside. Maybe you want that watch, right? Or you want that item that's going to somebody else. You owe them that duty, so you have to put that aside, and it's really tough. We have seen a lot of trustees get into trouble where they think, oh, I'm going to blur the lines a little bit here or take a different approach there. And I think that scenario really gets tough.
Yeah. Sort of the idea of sort of the idea of, dad's watch might not be that valuable, so who's going to notice?
Right. That's exactly right. Who would know?
Somebody's going to notice.
That's right. Especially the person that's going to inherit that watch. So you want to be very careful. Another thing with trust administration is you will be responsible for filing the tax returns for your father's personal estate. And if there is one, the final return for your father, and then if there's one due for the trust itself during administration. So there's a lot of I's to dot and T's to cross on that. I remember we had a client come to us once late in the process. She had stepped in to be trustee, and she had not filed taxes for her deceased mother. She had not filed taxes for the estate, and she had not distributed the assets because she was getting paid on the assets. So she held them in trust, and she was being sued by her siblings because after multiple years, she just didn't want to distribute the trust because it wasn't in her best interest. We had to give her counsel to follow the terms of the trust. That was her job.
Because again, that's a serious breach.
That's right. That's exactly right. And so she had the risk of being sued personally inside that fiduciary duty because she wasn't doing that. And I don't think she was trying to be malicious. I have seen some people that are malicious, but in this circumstance, she was just scared about taking that next step. She didn't know what to do, so she froze. And inaction is a luxury the trustee doesn't have. If you're successor trustee, you really need to move forward and try to get things wrapped up as best you can. So again, let's go back to your father's estate. He's passed away. You're dividing all these assets. The mineral rights are fairly easy. You can do deeds for that. But one thing that I would encourage you to remember to get when this happens, right, when you're trustee, is to get releases from all the beneficiaries.
Okay.
So what is that? Well, when you give the watch or the minerals or whatever or the cash to the other beneficiaries, make sure that they acknowledge they've received it.
Yeah.
Make sure they acknowledge that you've done your job and that they're releasing you from future work, right? That's very important.
You got to have the receipts.
That's right.
Basically.
You got to have proof that the transaction happened. So we have seen a lot of trustees get in trouble when they say, "No, I did do that. I gave that to you," and maybe they didn't know. And one last thing, and this is probably the single largest piece of advice I could give to somebody that's going to be in your shoes, right? They're going to be a trustee, a successor trustee, is information, sharing the information. Because most people believe, right or wrong, that there's more money out there, right? Show me what else Dad had. Show me what else was there. And you're looking at all the assets going, well, how do I show you what's not here? If it's not here, I can't show you. But people sometimes believe there's always more assets that are out there. And in my experience, we have a lot of wisdom and a lot of years, and we've made our own mistakes about how do we share that information. What's the best way for a successor trustee to avoid those lawsuits that are kind of searching or discovery in nature, where they're just trying to figure out what else is there. We have a lot of ways that we can do that, and I would encourage the successor trustee to be transparent. Right? When you step in to be the successor trustee and you are administering this, my advice to you is to be transparent. Show all the information you can, even when you don't have to. Even when you legally think, oh, this is overkill, you need to share it. And we can help a lot of clients through that by not oversharing, but at the same time being transparent, because it is really, really hard when people think that maybe you're hiding something and they want to know what it is that you know that you're not telling them. Right. So
it sounds like that that need for clarity and transparency is a bit of a through line there, actually, through the entire process.
That's exactly right. Most people are, in my experience, not everybody, but most people are down to earth, and they want to do the right thing, and they want to honor the grantor's wishes and make sure they're carried out. But sometimes they can become a little distrustful, and sunlight or sharing the information really does a great job to pour water on that fear of not knowing all those details. So I'm so glad that you asked that question. What happens if I'm the trustee, or excuse me, what happens if I'm administering a trust or I'm named trustee? What do I need to do? And I would encourage people just not to be nervous about it, not to be scared about it, but also to respect the task that's been given to them. respect the challenges in front of them, and understand what they're getting ready to do is complicated. And what they're getting ready to do has a lots of ins and outs. And a good attorney can help them navigate that. They don't have to hire an attorney, but it can certainly help them navigate
Right.
it.
I was about to say, luckily there's help.
That's right. That's right.
Yeah.
There is help. The other day, you'll like this, Nick. I did replace my hot water heater in my house. I didn't do a very good job
Sure.
because it was the first time I'd ever done it. Not many people get practice or being a successor trustee.
Right.
So if you do it the first time, it's probably going to be your only time that you get to do that.
It's not something you want to make a habit of.
That's right. That's right. That's right. And so when you do that, it's wise to seek counsel, someone that can help you navigate the ins and outs of navigating, serving as a trustee, and doing a trust administration. Nick, thanks for coming by today.
Thank you so much, Brian.
Thank you for listening to Fortifying Futures. This is the podcast that unlocks all the secrets and all the mysteries surrounding estate planning. And we want to make sure that we're answering all your questions. So keep them coming. Let us know what's on your mind. Let us know what concerns you may have or anything that we didn't get to. We'll do our best to get to those on the next podcast. And you can reach out to us via email at clientintake@bml.law. Again, that email address is clientintake@bml.law. And you can always call us at 405-701-5355. Again, that's 405-701-5355. And check out our website at bml.law. There's a lot of great information out there, a lot of great resources and tools. And our goal at Balmore Slow is to provide thoughtful law for today and in the future. Thank you.